proper or the strict sense according to Austin? Law is the command of the political superior, and that is known as the imperative theory of law. How we derive the definition? How we derive the definition of law from this theory?
So, law is the rule of land laid down by political superior for political subordinate that has control over the other.
Yeah. Law is a rule laid down by a political superior or a political subordinate of inferior, where one has power over another. Simple. What are the three pillars of the Austin theory? What are the three pillars of the Austin theory? What?
Sovereign, command and
Sovereign, command and sanction. Sovereign is sovereign because he is all powerful. He has got the power to issue commands. And then commands are, what is the alternative left with you? If a command is issued, you have to be obeyed. You have to obey. It has to be obeyed. Why? And if you don't obey it, then why? What will happen? If you don't obey it, what will happen? There is force and sanction to enforce it. समझे ना? इसलिए हमारे सिस्टम्स में यही होता है. Which sources of law you have done? कौन कौन से sources पर किया आपने? Sources of law किए नहीं किए? क्यों होंगे ना क्लास में? Sources of law नहीं किए थे? नहीं.
maxims, policy and decisions.
क्या?
Maxims,
Custom.
Maxim
किया है. Schools नहीं किए. नहीं ये sources. Sources of law you have not done in legal method.
maxim is also
Maxim is not sources.
Custom precedent.
हाँ वो बोलिए ना. Custom है. Judicial decision. Never say precedent means. Precedent can be any precedent. Judicial decision. Third, legislation. So the three important sources of law which you will study in legal method are custom, legislation, and judicial decision. Right? So as far as analytical postulation of Austin was concerned, it says law is obeyed because it's the command of the political superior, sovereign. And if you don't obey it, there is a force sanction. Right? And that's why the most significant contribution of Austin is, what is the significant contribution? What is the significant contribution of Austin? Before Austin came, there was no clarity about the meaning of law, definition of law. When he gave this definition, the clarity came to the definition of law, where he discussed law in the proper sense, in a strict sense. And he said, for me, in a strict sense, proper sense, the law is the command of the political superior. So what is the contribution? What is the contribution in one line? I give it to you. ये सब चीजें लिखवाई हो यहाँ.
Law should be taken.
The contribution is, please remember friends, law can be made. Law can be made. So he gave us a theory where he provided legitimacy to a group of people or a person like sovereign or political superior. They had the power to make a law. Law could be made. What does that mean? What does that mean?
That it is not something inherently natural that it
Law became, लिख लीजिए सेंटेंस के प्लीज, राइट डाउन. जो कॉपी और पेन लेने की तकलीफ करके आए हैं वो ले लीजिए, जो नहीं आए हैं वो मौज करिए. Law is the manifestation. Law is the manifestation. आगे क्या है? Law is the manifestation of will of the state. Law is the manifestation of the will of the state. What does it mean? According to Austin, कितना सरल कर दिया. Law is the manifestation of the will of the state. It means what? क्या मतलब है इसका? What does that mean? Yeah.
It means that the state has the discretion.
No discretion. State has the power.
state has the power accordingly.
Simple. Whatever law you want to make, you can make. The sovereign, the political superior, by the theory of Austin, that the law in the command of the political superior was given a power. कि आप जो भी चाहें वो कानून बना सकते हैं, आपको पावर है. That law you can make through parliament, right? Or you can make it through the state legislature. एक power दे दिया, and that's why if you seriously look at it, maximum legislation statutes जितने भी है ना, they are the manifestation of the will of the state, है ना? That's why legislation in the modern times is one of the most important sources of law. समझ में आई बात? Legislation in the modern times is the most important sources of law. Why? Why it is important? Why it is important? Why? Answer दीजिए. गलत होगा कोई बात नहीं, गलत नहीं होता कोई आंसर. But try to answer. Yes.
Legislation forms most of the acts and bills that passes that.
We see the idea is maximum law is in the form of legislation. किसी भी country में, किसी भी देश में maximum law which we find is in the form of legislation, which is come through the instrumentality of the state, the sovereign, the political superior. So legislation is the most important source of law. Right? Can you criticize it? Can you criticize Austin? क्या करते कि कौन Austin है?
So he allowed for despotism in a form because the sovereign was not subject to his own laws.
Wonderful. You're very right. When you say law is the command of the political superior, what law applies to the sovereign? Because he makes the law. Do you mean to say that your sovereign will abolish the law? So leaving a sovereign above the law is very, very dangerous. In a rule of law society, everybody is under rule of law, under law. Nobody can be superior than the law. And if you do that, it can be dangerous. It happened in certain countries like Idi Amin, you know, but Idi Amin that overnight said all Asians should leave the country. And then the kind of repression people faced. Right? So if you make the sovereign all powerful, then there can be problems. Then any command can be law. It may be good, it may be bad, it may be reasonable, unreasonable, moral, immoral. That is also not a very good thing. Right? So that's why, and then the historians, those who gave definition of law in tune with the historical movements of a particular state society, they said, Mr. Austin, where is the society? Law किनके लिए है? For whom the law is made? Society. Where is the society? Society तो कहीं है ही. एक sovereign है, वो command करता है, बाकियों को obey करना. What happens to the society? Do you think law is like this? You can't keep the society away. So the jurists of the historical school, please clearly bear in mind, said that the Austin's theories are historical. है ना? वो भी बताया ना आपको. The Austin's theory is unhistorical. Unhistorical. Unhistorical क्यों है? Why it is unhistorical? Why it is unhistorical?
It is not typically the reason because of which people follow the laws.
हाँ? Unhistorical क्यों है? Why it is unhistorical? It is unhistorical because the jurists of the historical school said, Mr. Austin, don't forget the present and the past are very closely related. है ना? You cannot understand the present. You cannot understand the present unless until you understand the past. Can you understand the present of the law? Unless you understand the present, past. You will get into 1935, 1947, Constitutional Assembly, all those developments which help in the making of the Constitution of India. Then only we appreciate what the Constitutional law of India is. So how can you understand a particular law without appreciating the past? Because the past and present are very closely related. Right? So unless you study law in that linkage, you will not be able to understand it because the present is mirrored in the past. And the present can be understood better if you study the past also. Right? So the past and present are very important. So in that direction they say it is also important to study the origin and development of law. How a particular law originated in the society, uska janam kaise hua, and how a particular law developed. Every society is different. That is the reason that we do not have a uniform universal law for each and every society. सब सोसाइटीज के लिए लोगों के लिए कानून भिन्न है ना? जो साउथ में है वो नॉर्थ में नहीं है. In the same country, it is different. Different communities is different. It is different in USA, different in Canada, different in India, different in North India, South India, East India, West India. Why? Huh? Why? They said law is like language. Law is like language. And law will speak the language of the place. Law will speak the language of the place where it is born. जहाँ उसकी उत्पत्ति होती है, where it is born, where it takes birth. So law is different for different societies. Different for different societies. So they said law is not the manifestation of the will of the state, but law is the manifestation of the will of the who's that? People. Will of the people. And 70 said, if you will, somebody will ask me what is law, for me law is Folkist. 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 And we pronounce that Folkist, written as Folkist. Folk means people and this means spirit. Law is the spirit of the people. Law is the spirit of the people. So he said you can't keep law away from the society. Law and society has got very close connections. Law is not imposed from above, ऊपर से नहीं imposed किया जाता है. It grows. It grows in a society where it takes birth and develops. And they say that's why law is the manifestation of the will of the people. And that sentence I gave you grows automatically because of the silently operating internal forces. Grows automatically because of silently operating internal forces. And where those forces operate? Where those forces operate? Huh? Society में. Those forces operate in the society. किसी को नजर नहीं आती है, किसी को नहीं दिखती है. Nobody knows how they operate. But in that process, a kind of churning happens and it gives rise to a very important source of law, another source of law, that is customary law. Right? And in the form of law, there is in the form of social control. Right? How many of you from a village side? Many of you from the village? Yes. Many of us from the village. Is proud to be in a village, come from it. I am proud of it. So if you come from the village society, we don't have anybody to implement the law. You will find that most of the villages, they have their own inbuilt mechanism, rules of behavior, rules of conduct, and the society is kept intact because of those rules and behaviors. What are those social modes? Every society will have their modes of social control.
Customs traditions.
कौन से control है? Modes of social control. These are not common sense answers. What are the modes of social control which binds the society together? in the countryside where there is no Austrian sovereign present. कोई policy चौकी नहीं है वहाँ पे. People still are law-abiding. No? Social mores, social values, traditions, conventions, usages, and then customary law. ये भी सभी modes हैं social control के which binds people together, and nobody dares to violate those laws. Then not because there is a sovereign or there is a command of the sovereign, but because of the they don't dare violate it because of the social क्या command है वहाँ? Why they abide by law? There in a society.
Social acceptance.
Social pressure. Social pressure act. Every society creates a social pressure where you do not violate the norms of the society, their customary practices, their usages, their conventions, their traditions, their social values, moral values. Because if you do it, society has its own mechanism to enforce those laws. आपको गांव से बाहर कर देंगे ना, जाति से बाहर कर देंगे, गांव से बाहर कर देंगे. Extreme example I gave you, hate killing. Extreme example, I'm not saying it's good, but there is an extreme example of hate killings. It happens all over the country, and more so in North India. South India, I don't know. North India is very common sometimes. Of course, it's not a good thing, but at the same time, there is a social pressure which makes us to bind the law. So, according to the historical school, law is the fourth gist of the people, that is the spirit of the people. And law is binding because of social pressure. क्या force है? What is the authoritative force? Force is the social pressure. And what is the source of law? Customary law. How customary law is important? How customary law is important? We find a sizable population in the world are governed by customary law. Who are the people governed by customary law? Who are the people governed by customary law? Which communities are governed by customary law? Huh? जोर से बोलो.
Tribes and
हैं?
tribes and backward communities.
क्यों भाई? हिंदू नहीं?
Yes, sir.
फिर tribes and backward communities क्यों? आप बहुत फॉरवर्ड है.
Yes, sir.
Hindus, Christians, Parsis, Muslims, Sikhs. The whole range of population is governed by customary law. Is governed by customary law. Very important law is customary law. Hindu law even today is in two parts: codified, uncodified. Like marriage is codified, partition is not codified. The large part of this is not codified. कोई law नहीं है, वो customary law ही है. Right? And even today, when we have a legislation on certain aspects, customary law is still important. And I give you the example of marriage, section 7. Right? Capacity of a Hindu marriage. Then a marriage between Hindus, two Hindus will be solemnized when the customary rites and ceremonies of the parties there to the marriage are performed. It is customary law. It is not given by any political superior. What does that mean? That means if there is a marriage between a Hindu boy and a Sikh girl, both are Hindus under the definition of Hindu. So marriage would be solemnized only when the customary rites and ceremonies of either parties, either of the boy or the girl, are solemnized. Either party means if it is a Hindu Riti Rivaj, then Saptapadi. Right? If it is a Sikh Riti Rivaj or Sikh customary law, then it is Anand Kaj. Anand Kaj, taking the 7 steps round Guru Granth Sahib to the Gurdwara. Right? And whereas in case of Hindus, it is Saptapadi. You may perform this, you may perform that, you may perform both of them. No problem. But if you do not perform any of them, and you perform something else, marriage will not be valid. I gave you that case of A.N. Mukherjee versus State. You should see the reports, or maybe you can find in the, must be in the digital mode also. AIR, A.N. Mukherjee versus State is a beautiful love story. Like to live it. I remember it because we did a mock on this in my student days. A.N. Mukherjee versus State. AIR 1969, Allahabad. You say Allahabad High Court, not the Supreme Court. Allahabad 489. You read this case, wonderful case. Three kinds of ceremonies happen. One before the moon, I'm yours, you are mine. Exchange of garlands in the temple, and then taking 7 steps. And then another in the Kali temple, taking some steps there. And the fellow made to believe that lady who was already married, that now marriage is complete, consummated the marriage. But the A.N. Mukherjee was a doctor, was not married. This lady was married. She was from Ambala, Punjab, very beautiful lady. She was a doctor, so they married down. And ultimately, the husband went to the court of law and sued the wife for bigamy. Wife against चला गया, that she is guilty of bigamy. What is bigamy?
Marrying
When you marry again, you are already married and you marry again. But what happened? The court said, explain to us whether customary rites and ceremonies are performed. Certainly, then give evidence whether customary rites and ceremonies are performed. And the court said, sorry, customary rites and ceremonies are not performed in civil marriage. So this means you may perform thousands of ceremonies, but if the essential ceremonies are not performed, marriage will not be valid. So the lady was not guilty of bigamy. But the doctor was hauled up for other things because he siphoned a lot of money from the lady's bank. So that's why he became A.N. Mukherjee versus State. He was liably criminally, but not under the marriage. Bigamous marriage could not be proved because there were no essential ceremonies. So people say those who have to marry should be very, very careful. Those who especially go for love marriage, and those fellows who are very smart, who bring the ladies, they should be very careful what kind of ceremonies are being performed. And if the essential ceremonies are not there, gentlemen, sorry, there is no marriage. The marriage is not valid. Nobody will reply, the court will not reply this marriage is valid. Unless and until signed with. समझिए है ना ये तो याद रखना चाहिए ये काम की चीज हो सकती है It's important for everybody, especially the girls. Anybody can make to believe that essential ceremonies are being performed, है ना? चलो यहाँ पे राउंड अबाउट पे 7 मिनट दे देते हैं डायरेक्ट एक्सचेंज करने की मैरिज होगी No, it can't be any ceremony or every ceremony. It has to be customary rites and ceremonies of the parties there to the marriage. एक की हो जाए, दो की हो जाए, दोनों की हो जाए, no problem. That is the important custom. Permanent degrees. Within permanent degrees you can't marry. Right? So that means, in spite of the fact that we are governed by legislation in a big way, but the days of customary law are not over. Custom still plays a very, very important role in the lives of many, many communities. And it's a very important source of law. Because it is the focus, the common conscience of the people, it grows out in people like language and it varies from place to place. That's why customs are different for different societies. And they are bound because of the social pressure. The sanction is the social pressure. Because of the social pressure, we do not violate a custom which is present. And a custom, in order to be valid law, it should be it should have certain valid requirements. What are those requirements? It should be old, certain, continuous, reasonable, not opposed to public policy, not opposed to law. Right? So that is the importance of the historical school of jurisprudence, that they say that if you want to understand law as to what law is, then also look at, analyze the law as it, not as it is, but as it was. As it was. That means look at the origin and development of law. How the origin and development of law happened. How law originated in a particular society. How it developed. And in that fashion, you look at all social control, all social values, social norms, conventions, traditions, rules of behavior, usages, and customs. That will prove that what kind of law prevails in a particular society. So law cannot be uniform, cannot be universal. It is different for different societies. Because it will become the language of the place where it is born. Right? Because all societies are different, so law cannot be the same. In spite of the fact that the sound is the same, but the customary law will be different. And that's what happens even in India life. That's why I told you that many laws in North India are different, South India is different. And the most important example is Daya Bhag law and Mithakshara. Now, what is Mithakshara law? What is Mithakshara law? In North India, as far as the property of the father is concerned, you are born with a silver spoon in your mouth. The moment you are born, you get a share in the property of the father, family. In South India, it is not like this. You only get a property, interest in the property of the father when he dies. Right? That's the difference between Bhaga and Mithakshara law, and that is because of the peculiar customs in North and South, which makes very important. That is the law. That is the law. That during the lifetime of the father, in their work, the son will not get any share in the property. It is only after the death of the father. Whereas in Mithakshara, in North India, one gets a property interest right to the father. So they are very, very significant and important decisions. So life is like language. Like the language will vary from place to place. Tamil is different, Telugu is different, Kannada is different, Hindi is different, Punjabi is different. So that's why they say law is also different for different societies. ठीक हो गए? समझ में आ गया? Right. Next is sociological school of jurisprudence. Now, you will appreciate that it is a historical school which related the life of law with the society. Life of the law with the society. Society के साथ उन्होंने bind कर दिया. But the jurists of the sociological school, they say, they go ahead. They say we are not bothered whether the law is in the form of customs or whether it is in the law form of legislation, whether it is made, whether it is grown. But we understand, for the understanding of law, what is important is we need to analyze right down. We need to analyze not the law as it is, not the law as it is, not the law as it was, but which law? What it does. Not as it is, not as it was, but what it does. जो कानून आपने बना दिया, जो लेजिस्लेशन ने कानून बना दिया, जो कस्टम्स की फॉर्म में है, what it does, what is the role of that law in the society, we need to study that. And we will understand the nature of law better when we understand, try to understand that whether that law has got any function in the society. Any function in the society. That's why this school is also known as Functional School of Jurisprudence. Sociological school is also known as Functional School of Jurisprudence. They look at law in terms of function. The law का function क्या है? What it does. Whether it has got any role to play in the society, because law is a means to an end. Law is a means to an end. Every society will set up certain aims for its development. And law is a means to an end. Through that medium of law, they want to attain those ideals. And the most important jurist of the Sociological School of Jurisprudence is Roscoe Pound. R-O-S-C-O-E P-O-U-N-D. Roscoe Pound. Roscoe Pound. And he said, if anybody will ask me what is law, for me law is, write down this sentence. Law is social engineering. He defined law as social engineering. Social engineering. What is the meaning of social engineering? बताइए, तो समझना क्या है social engineering? The task of a lawyer is like that of an engineer, architect. If you have to make a law, you have to see whether that what you function in society or not. अगर आपको if you want to make a hall, you can't make a classroom. If you want to make a hall, you can't make classroom because then it will not serve the purpose of a hall. So they say, look at what is your purpose of making a particular law. Give me examples of the sociological school if you have in mind, where a law should be functional, relevant to society for which it is made. They say, we don't bother who makes the law, but we are bothered whether the law is functioning properly. That is very important to study, whether the law is functioning. Because social engineering, the task of a lawmaker is that of an architect, engineer. He must decide whether a particular law will work in this way. You understand a car better when you sit down inside and see how a car works. If you look at outside, you don't understand the working of a car. So go to society, see the working of the law. Then you understand and appreciate as to what law is. Give me examples.
Work bill, work act.
Huh?
Work act.
Of course. Anybody, anything else?
So the technicalities like the age when the crime has been done, like the
Yeah.
criminal justice and
Give me a concrete example of a law. There are so many examples in Hindu law, in our system.
Domestic violence, against domestic violence.
हाँ? अरे डाउरी लॉ भाई, डाउरी लॉ है. जैसे डाउरी लॉ आपने बना तो दिया. Do you think the purpose is served? The jurists of the sociological school say, do you think that by only making dowry law and making the provisions stringent, the purpose has been achieved? क्या हुआ? What happened? We found dowry law is highly defective. Why? Because it was misused like anything. Sometimes the whole family was behind bars. The mother-in-law, the daughter-in-law, the other relations, those were not even near the family anywhere in different societies, sometimes abroad. The name of all peoples were given in the FIR and they were problems. And many years it went on. And then they say, go to the study, find out, see in society, meet those people who were victims of dowry. उनसे पूछिए क्या हुआ? What happened? Why every time it is daughter-in-law? Why don't the daughter burnt in a stove or in a gas? Why एक incident जिसमें daughter को fire हो गया kitchen में? Daughter-in-law को क्यों होता है? Why daughter-in-law every time? They said why? There is something wrong with the law. Law is not functional. काम नहीं कर रहा है ठीक से. So they say most important thing would be study the functioning of law, go to the society, see what is wrong with the law, and then suggest how those means for which a particular law was made would be achieved. उसका objective कैसे achieve होगा? Why? How it will be functional? Right? Another example: child restraint marriage. You see in North India in certain states, I don't know about South India, thousands of child marriages are performed. There is a marriage season, thousands and thousands of child marriages are performed. And then we had a law, Child Restraint Marriage Act 1939. That's a child marriage is restrained. Restraint लगा दे. What does that mean?
Should not be.
Huh?
Prohibitory.
What does that mean? Child Restraint Marriage Act 1939. रोक लगा दे. Restraint means रोक लगा दिया. Child marriage नहीं होगी. But what does that mean? Is the law functional? Could it stop the child marriages? No. Because it could put only restraint. Some punishment, some fine was provided, but it will happen only when somebody will complain. But why anybody should complain? Why your neighbor or relation should complain? There is child marriage. Why should they spoil the relations? So no case came to the court where it was being violated. So people found that the Child Restraint Marriage Act is absolutely non-functional. Non-functional act, and that's why the child marriages are carrying on. Unabated. Still thousands and thousands of child marriages are happening in every year. And child marriage under this act was legal. The worst part was the child marriage was legal. It only provided provision. Restraint किया, मत करके. If I tell you भैया ये मत करिए, शोर शराबा नहीं करिए. अगर आपको करना है तो आप करेंगे. If you daily do it, why should I tell you कि have you done? When you still do it, tell it. No. नहीं. That's how that they say it's very important to see whether a particular law is functional, whether the purpose for which it was made is being achieved, whether those means are being achieved. Another example is environmental law. No, we have water law, we have air pollution law, we have the production of environmental act. We have one of the best laws in the country, but we think we have taken care of environment. Come to Delhi now in November, December, smoke, and you see the quality of the air. People survive it very difficultly, and then it can be so dangerous for children. Let me say what happened to your environmental law. What happened to your air pollution? People are suffering, they are in a bad state. Old people are dying because of the pollution, and it affects their lungs, and they are getting all kinds of diseases. So that in that case, the importance of the social school is that they say make it functional. Go to the society, study it, whether dowry law is working. If it is not working, study it. Suggest. Suggest and means so that it is functional. Study air environment, air pollution law. Study water laws. Study all your laws and find out if they are working. Like if your Sati Pratha Act is not working, then find out how it will be working. Huh? And then I read a wonderful provision to you. Article 17 of the Constitution of India. The fundamental law. Listen, Article 17 is abolition of untouchability. Right? Abolition of untouchability. Article reads, untouchability is abolished. Untouchability is abolished. And its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. Article 17 of the Constitution of India applies sociological school of jurisprudence. What is the reality today after more than 75 years of independence? क्या हुआ? Untouchability is abolished. As per the Constitution, untouchability is abolished. And anybody found practicing it is guilty of punishment. You saw the other day what happened to Jesus Bhatia. If it can happen to Jesus Bhatia, who is from a Dalit family, what are you? तुम क्या चीज हो भाई? तुम किस खेल की बोली हो? What are you? And will take no punishment. So the jurist of this hospital could say, देखिए क्या हो रहा है? See what is happening. Is your law functional? If your law working, if your law is not working, what is the law for? If the purpose means are not being achieved, then you need to change that law. You need to change that law, need to make that law effective. I am from North India. We don't have much of anti-security law. Very little in some pockets. But I learned South India is still in the bad shape. South India is practiced in a very big way. You still can't enter certain temples. You can't still enter certain places of worship. You can't still sit on a cot in front of the Jamidar Sahab. You know, read the Article 17 of the Constitution House. It's a fundamental law. And they say that to implement it, you can pass the Protection of Civil Rights Act. Protection of Civil Rights Act. What happened? We also have the Protection of Civil Rights Act. It was misused rather than used. It was not used in the genuine cases. It was misused in the just to frame some people, just to trouble them, just for harassment. So it all was misused. So the jurists of the Supreme Court are saying, please go to the society and see what a particular law given by legislation or in the form of customs, your Sri Pratha, your dowry laws, whether they are functional and how to stop those kind of practices which are against the society. No, those kind of practices which are against the society, how to take care of them, what kind of reform you can suggest. Do an empirical study of laws so that you make them more effective. The sociology school of these things. And if we look at those 5 questions, what is that element? 5 questions. What is the element of law? What is the nature of law? What sources? What is the authority? What philosophical views? What is the element then according to the sociological school? All forms of social control. I told you. Conventions, traditions, social move, social values, usage, customs. The element is, they say, study all these elements. Right? And then, what is the nature? Nature of law is also coercive. Coercive है. Like question is also coercive. Where from the coercion comes? कहाँ से आता है? It comes from society. In the form of, it comes from society in the form of pressure, social pressure. So what is the authority behind law? The authority behind law is social pressure. You can't marry a Smita, you can't marry a government degree because there is a social pressure. Right? And what are the sources? All social welfare legislation. All social welfare legislation in any country or in India is the outcome of the sociological school of jurisprudence. All social welfare legislation. Name again, there are three social welfare legislation. You have in mind. All social welfare legislation. Huh?
EWS. EWS.
Huh? All social welfare legislation. इतने सारे तो अभी नहीं किए ना, we don't see that yet. No, charges may indulge in. Whatever social relations come, it is because of the outcome of the social school of jurisprudence. And the most important is trade union laws. Trade union laws. Trade union laws. Those laws came not because a particular sovereign wanted it. इंडस्ट्रियल वर्किंग के लिए कोई sovereign interest नहीं है. It came because the section of the society wanted that kind of law. It will serve a purpose. No, those kind of laws are the outcome of the social legal school of jurisprudence, right? And then Roscoe says, listen carefully. In any society, there are three kinds of interest. Three kind of interest. My interest, individual interest, public interest, interest of the public, and the state interest. These three interests keep on conflicting. They conflict करते हैं आपस में. 1, 2, 3, they keep conflicting. 1 may conflict with 3, 3 may conflict with 2, 2 may conflict with 1. All the time there is conflict between 1 and 2, 2 and 3, 3 and 1, 3 and 2. Right? Example? Give me some example. Right? Recently in the newspapers, there was a news item from Kerala, some cough syrup. Cough syrup, for example. Huh? How many children died? By consuming that cough syrup, how many children died? Don't you think there is laws all kinds of regulating those kinds of manufacturing of those medicines or syrups? And when it was found, there were more than 1,000 violations. That unit who was manufacturing the syrup, there were more than 1,000 violations of law. Right? That means the law which was there for regulating those kind of activities was not effective. It was not functional. Ultimately, it was found it was because of the violations. It was because of the violations that so many children died. So you find there is a clash of interest. What is the clash of interest? That factory owner wanted to be rich. At whose cost?
Public.
At the cost of the public, and they also collided with the interest of the state. So there was a clash of interest between the individual, the public, and the state. And they say to make the law more effective, functional, so that the ends will be achieved. So the ends will be achieved. क्या बात है? आप तो सामने बैठे बात कर रहे हो. So that the ends will be achieved, you have to make that law functional. That means those clashes have to go. What does that mean? Then what is the law for? What is the law for? When we have to take care of the clash of interest. Tell me, what is the law for? What is the function of law? Common sense answer. What is the common sense answer? Law है किसके लिए?
Settling those conflicts.
I mean,
To settle those conflicts.
हाँ. Simple answer. Yes. Tell me what else? Roscoe says when there are these kind of interests in the society conflicting, law has to take care of these conflicting interests. So that these kind of conflicting interests do not multiply. If the society has to live in peace. So what is the role of law? What is the role of law? Law basically. Law is a harmonizer. Harmonize is a harmonizer of the various conflicting various conflicting interests in the society. ठीक है ना? Harmonizer of various conflicting interests in the society. कि मैक्सिमम रोल क्या है वहाँ पर कि जितने भी conflicting interests हैं उनको कैसे हार्मोनाइज करें so the society lives peacefully. And because these interests will keep on changing from time to time, so the law will also change from time to time, from society to society. It can never be static. It cannot be universal. Right? Now that is the peculiar nature of the law. So for Roscoe, what is the definition of law? Law is, as I said in the beginning, social engineering. You have to constantly look into the mechanism of the society and find engineer whether a particular law is working or not. If it is not working, what changes are required, what reforms are required so that it is working properly, it is working efficiently. Right? That's what basically the jurists of the historical school of jurisprudence are saying. No, sociological school of jurists are saying. Right? And for them, their possibilities are diverse. They do not subscribe to any particular theory as far as the theoretical foundations are concerned. They say different things at different points of time. So that's briefly the in nutshell is the essence of the sociological school of jurisprudence. Right? Any question? Any question on that? Before I proceed to the next one? Right? Can I proceed to the next one? Okay. Next is the realist school of jurisprudence. Next is the realist school of jurisprudence. Realist school. Realist school of jurisprudence. Next one is मैं IELTS कर लेता, मैं सिविल सर्विस में आता, मिलिट्री में आ जाता, उन दिनों सीरियसली हुए, जब को सिंह आते थे दिल्ली से बहुत कहते थे पढ़ो, लेकिन हमने तब तो कोई ध्यान ही नहीं दिया, तब तो शादी की चिंता लगी थी, कि ये पता नहीं कब 5 साल पूरे होंगे, तब चाहिए होगा, नहीं तो होता रहेगा, नहीं, लेकिन अच्छी बात है, अच्छे मिल जाए सब कुछ पढ़ लोगे तो अच्छा रहेगा, नहीं, people have really made their career, they have had very good places from the law schools, कहाँ लोग पहुँच गए, नहीं, अभी आपने वो नाम नहीं कमाया, sorry to say this, Visakhapatnam has got that name, that any school has done some very exceptional work, so that we say, oh my God, DSNLU has done a wonderful job. इसका मतलब आप मेहनत नहीं कर रहे, routine में you take your bath, take your breakfast, or maybe if you don't take your bath also, तो टाइम नहीं आपके पास, सुबह उठते हैं आप रात को जागते रहते हैं, तो ब्रेकफास्ट का भी टाइम नहीं होता, आज में आपके ब्रेकफास्ट है क्लास में आ गए, 7 हो गए, ऐसे ही स्कूल लाइफ में all kinds of things happen. Any questions on sociological school before I proceed further with the realist? The 3 sources of law I said are custom, legislation, and third is judicial precedent. What is the theoretical base of judicial precedent? Why? Why judicial precedent is another important source of law? Please speak loud.
Those judicial precedents sets an example which can be taken.
Judicial precedent sets an example which are working as stay and decisis. That means we should be followed. Right? That means a judgment given by the Supreme Court of India is binding on all the courts of the country. Okay, na? Right? And the most important jurist, listen to me carefully, the most important jurist in the school of jurisprudence is Justice Holmes, Holmes, Chief Justice of the Supreme Court of America. Chief Justice of the Supreme Court of America. And he said, where is the difficulty? If somebody will ask me what is law, कोई difficulty नहीं है. It's very simple. And he said, I give you an example. And the example he gave, ask a bad man who has done some offense and whose case is going in the court of law. Any bad man who committed some crime and his case is going in the court of law. Ask that bad man, what is law? क्या answer देगा? What a bad man said would answer. His case is going in the court of law. What would be his answer? Any bad man whose case is going in the court of law. What would be the answer?
Law is arbitrary.
That?
Law is arbitrary.
Next.
Law is punitive.
हाँ?
Law is punitive.
वो आदमी क्या करेगा? जिसका केस कोर्ट में चल रहा है.
Law is exhaustive.
He would say, let us see what the court decides. Simple. किसी बैड पर्सन से पूछेंगे, आप बैड पर्सन से पूछेंगे, sir, case is going to the court of law. The court is to decide what will happen in this case. वो कहेगा मुझे कुछ नहीं पता, किसी को नहीं पता. Let us see what the court decides. So for him, the law will be what the court say it is. Right? So the jurists of the Realist school of jurisprudence see the working of the law through the medium of the courts. Through the medium of the courts. And Justice Holmes says that a judge sitting in a court of law, judge sitting in a court of law is a very powerful person. How he or she is powerful? He or she is powerful because they have got a tool of interpretation. They have got a tool of interpretation in their hands. कौन सी शक्ति है उनके पास? ब्रह्मशक्ति. वो क्या कहते हैं? कौन सा ब्रह्मशक्ति है? Interpretation. They say that judges are so powerful that whenever there is a case before them, they can interpret it the way they like. And the law would be what decisions they give. Law would be what decisions a particular judge will give in a particular case. Right? So Justice Holmes said, like he gave the example of the bad man, he says, if somebody asks me, what is law? I would say, the prophecies. See what he said? The prophecies. What is prophecy? The prophecies. Predictions. भविष्यवाणी. भविष्यवाणी करते हैं ना, ज्योतिषी करते हैं ना भविष्यवाणी. कैसा वर मिलेगा, कैसी वधु मिलेगी, क्या होगा? आपके हाथ देख के मिलेगी नहीं मिलेगी वो पता है. The prophecies, what the courts are going to decide. Within commas, the prophecies of what the courts are going to decide. Nothing more pretentious. कोई pretend नहीं करता हूँ. Nothing pretentious. Nothing more pretentious is what I mean by law. No. The prophecies of what the courts are going to decide is nothing more pretentious than what I mean by law. मेरे लिए law बड़ा simple है कि courts की उस केस में क्या भविष्यवाणी है. What the court is going to decide. So the role of a judge sitting in a court of law is very, very central, is very, very important. They say law is made or bound, we are not bothered. But when there is a case before us, then through the process of interpretation, we decide to decide the case, and whatever we decide, that becomes the law. And then he further says, right in sentence, life of law is not logic, underline. It is experience. Life of law is a very important sentence of poems. आपके एग्जाम में आ सकता है. Life of law is not logic. It is experience. He says, आप 1000 बातें करते रहिए, 1000 लॉजिक दीजिए. But the life of law is not logic, it is experience. And where do you experience law? You experience law in the court of law. You experience law in the court of law. And that's why you find that after legislation, a major portion of the law, is developed through the medium of the courts. When you go to litigate, when you go to High Court or Supreme Court, when you litigate, and when you argue before a judge, what do you carry? What do you carry for supporting your case? Do you carry those case law books? ले जाते हैं advocates कितने सारे आपके juniors इतने सारे books लेके मिलते हैं. Or you carry all those cases which are in your favor to argue your case in the court of law. So that carries a lot of value. So life of law is not logic. आप कितना ही मर्जी logic लगाए, it is experience. Experience is what you experience in the courts. So whatever the courts ultimately will say will be the law. That's why the doctrine of stare decisis, S-T-A-R-E-D-I-C-I-S-I-S, doctrine of stare decisis is very, very important. Doctrine of stare decisis is case law. Case law developed by the medium of the courts. And you find that when the judges interpret the law, you find a great portion of the law already there in the form of legislation is altered, modified, amended by the medium of the courts. And after interpretation, whatever legislation may be, whatever the courts say it is, that becomes the law. For example, in Keshwar Bharti or ADM Jabalpur, for example, in ADM Jabalpur, what happened? I told you that during emergency, thousands and thousands of people, students, social workers, politicians, all kinds of people, intellectuals, were put behind bars. Right? And when the people approached the Supreme Court for habeas corpus, that we are inside the jail for no fault of ours, हमारी तो कोई गलती नहीं है. We have done nothing. Why we are in the jails? Do you know what the Supreme Court said? Look at Article 21. Article 21 says, nobody will be deprived of his or her personal liberty except by a procedure established by law. Except by a procedure established by law. Underline. Except by a procedure, except E-X-C-E-P-T. Except by a procedure established by law. And the Supreme Court, while interpreting this sentence under Article 21, in ADM Jabalpur case, which is a very landmark famous case, said, sorry friends, sorry guys, all those who are behind bars, we can't help you because the procedure has been followed. Because the procedure has been followed. What is your reaction? Supreme Court was criticized like hell. They said, people said to criticize Supreme Court, it's all right, the procedure has been followed, but the question is whether justice has been done. न्याय हुआ कि नहीं हुआ? The people those are behind bars without any reason, कोई justification नहीं है, उनका कोई fault नहीं है. Hundreds and thousands of people are lying in jails for months and months together. What is their fault? And if you say procedure has been followed, where is the justice? Article 143 we are saying It is the duty of the court, Supreme Court, to do complete justice. Complete case, because pluralist justice भी नहीं हुआ. नहीं. Then the Supreme Court realized its folly. उनको समझ में आया कि तुमने गलती की है, बहुत बड़ी गलती की है. इसको ठीक किया जाए. And the occasion to correct this mistake, what the Supreme Court had done was in Maneka Gandhi's case. Maneka Gandhi's case, right? And where they said, it is not any procedure, every procedure laid down by the court, by the state. It is not every procedure, any procedure. The procedure laid down by the state should be due process of law. Underline. Due process of law. A phrase which we avoided earlier in this constitution. In this case, it was interpreted as procedure established by law was interpreted as by the Supreme Court as due process of law. Underline. And those who are without pens and copies are missing very important things. Because these are all things to be noted down. Anyway, your choice. बहुत मस्ती करने आते तो हम क्या कर सकते हैं? You can take a horse with water, but can't force it to drink it. ऐसी कोई power तो है? ऐसा कोई sovereignty नहीं. No. So what happened after that? क्या हुआ? In one case, Gandhi said, it can't be every procedure, any procedure. It has to be due process. What is due process? The procedure laid down by the state must be just and fair. Principal underline कर दिया. क्या होना चाहिए? वो procedure क्या होना चाहिए? Procedure should be just and fair. Underline. अगर वो just and fair नहीं है तो वो it's a wrong procedure. The principle was due process. Just and fair principle was introduced, and it was after that everybody was languishing in jails. They were free. तो सबको बाहर निकाल दिया गया. Because they said sorry, this offense sorry. They said sorry, it was wrong interpretation of law. We have a duty to justice, and we failed to do justice because of certain reasons. And now we interpret this as it should be a due process, should be a principle based on justice, just and fairness. The just and fairness principle should apply to procedure as established by law, and now you are all free. So that is the power of the courts, and that's why you find so many cases in the High Courts, the Supreme Court, so interpretation, the High Court and Supreme Court have given you so many cases in the form of case law. Judicial President within bracket is case law, which is another very important source of law, which we call Judicial President. Right? So if you answer those 5 questions, what is that element? What is that element? Element is positive law. They say no problem. But that law is laid down by the courts. That law is laid down not by the court superior, but by the courts. Nature क्या है? Law की coercive है. Coercive है. Why? If you don't obey the orders of the court, what will happen? Contempt proceedings can be done. So coercive है. Right? And then the third, the authority granting law again is force and sanction. Implemented through the state. Force and sanction implemented through it is the duty of the state to implement the judgments of the state, the judiciary. And what is the source? What is the source of law? Judicial President. Judicial President within bracket case law. Right. So this is what is the in brief to make you understand what is the realist rule of jurisprudence, and that's why for Holmes he said for me law is not the command of the sovereign, but what the courts predict it to be. Prof. Holmes said prophecies of what the courts are going to decide, is what I mean by law. So those predictions are very, and life of law is not logic, it is experience. And where do we experience law? Day in, day out, we experience law in the courts of law. That's why judicial precedent is another very, very important source of law. So with that we conclude the other approach, that is the realist school of jurisprudence. Briefly, in nutshell, in the simplest possible manner. So tomorrow when I meet you in the session, we deal with the natural law, or the philosophical school we call it, but the more prominent name is natural law school. And after natural law school, we will wind up that debate. We will again be on that question whether after being through all these five approaches, whether finally we can now define as to what law is. And let us see what is the final answer after going through all these approaches, whether we can finally answer that question as to what law is. Is it possible to give a final answer? Is it not possible to give a final answer? If it is possible, what is the final answer? If it is not possible, what are the reasons? So with that we will conclude, and with that I will conclude my part of the unit which I am supposed to do, for which I especially come from Hyderabad to visit you. If you appreciate that, thank you very much. Any questions? My job is to make it very, very simple for you. Because when you go to third year, you again study all these things. But then you also study all those approaches and other jurists. And once you understand this, then it will not be difficult in the third year may after be difficult later. But if you don't understand it, nobody can make you understand. From books you cannot understand. So I thought I would like to make very, very simple. Any questions you have? Any question? Joseph already. Sorry, आगे बोलो.
Sir, what is the precedent, sir? That is my question.
Who?
Precedent.
Not precedent, judicial precedent.
Judicial precedent.
We are dealing with judicial precedent.
What is
We are not dealing
judicial precedent?
We are not dealing with. This is what we are dealing. Whole class. Realist school is judicial precedent. Only.
What is the meaning of judicial precedent, sir?
Huh?
What is the meaning of judicial precedent?
State decisis, case law. You follow the case law. The precedents developed by courts are judicial precedents.
Okay, sir.
Okay? Done. Thank you.
Okay, sir.
Okay. Anybody else? Right. Give the phone, give the mic, sir. इधर सामने.
So, what I've understood, the realist school of law deals with, so it basically states as a law is what the judges say, sir. So, law is what the courts decide.
Yeah.
Sir, so basically, according to the realist school of law is what the courts decide, sir. So,
Yeah. What we both say, have to say.
yes, sir. So, according to that, what is the role of the legislature in this school, sir? Because many of the times, what the courts deal with is what they're interpreting from the legislature, what the law is trying to say.
See, legislation is a source of law. What the courts do? They ultimately interpret a particular legislation, which is already law. Understand? It's already law. But once it comes to the interpretation of the courts, then the law would be what the court says it is. So that is the important. Otherwise, legislation is an important source of law. But once a legislation is challenged in a court of law, then the law would be what the court says it is.
But so what about those laws which have no cases attached to them?
No, they are very much law. As legislation. Unless it is challenged, it's a very much law. Right? So probably nature also is wider. Thank you very much.
One last question. Sir, how is the interpretation in the realist school of law is different than the judicial review? Or they both are same?
No, they are same because the Supreme can also make mistakes. They review their own judgments. That's why you have judicial review. And there is a judicial review, there is a appeal, there is a curative petition. There are multiple ways because everybody one is supposed to. Everybody can make mistakes. Supreme Court also make mistakes. No, right?
Thank you.